Good afternoon, everyone. My name is Preet Bharara, and I'm the United States Attorney for the Southern District of New York. After an 18-month investigation, we are here this afternoon to announce the filing of criminal charges against General Motors Company related to the company's failure to disclose a safety defect from its regulator and from certain purchasers of its pre-owned cars. At the same time, this office and GM have entered into a deferred prosecution agreement to resolve those charges. As part of the agreement, GM has agreed to pay a $900 million penalty or forfeiture. GM has agreed to the appointment of an independent federal monitor for a period of 3 years, and GM has made critical factual admissions. The monitor will be tasked with ensuring that GM's public statements about safety are accurate and that information related to recalls is shared appropriately within the company. The $900 million penalty that GM has agreed to pay is, by the way, in addition to the hundreds of millions of dollars the company has already agreed to pay to families of victims through a victim compensation program established by the company. That program has provided some measure of compensation for the tragic consequences of this safety defect. Together with the penalty imposed by GM's regulator, its total financial payments now exceed $1.5 billion, and that number is going up. The appointment of a federal monitor will ensure continued government oversight targeted at the issues that led to the tragedies that occurred here in the first place. In a case like this, as I think you'll agree, a case about public safety and about life and death, continued oversight is absolutely critical. So the resolution, as I said, includes detailed factual admissions by GM. The statement of fact details how GM designed an ignition switch for the Cobalt and other compact cars with such low torque that it could slip out of the run position into accessory or off while the car was driving. Cutting power to the engine also cut off power to the front airbags. So if the key slipped out of the run position during a crash, the driver and front passenger could lose the protection of those airbags. Now, GM knew about this low torque ignition switch for a long time, from the early 2000s, shortly after it was first installed. But it didn't fix the problem back then because GM personnel completely missed the connection between the switch and airbag non-deployment. They didn't then view the torque problem as a safety issue. In 2005, the company even assured the public that it wasn't a safety issue. Then, not until 2012, did they realize it was a safety issue after all, but they did not disclose it at the time they discovered that connection. GM's criminal non-disclosure of the safety defect lasted almost 2 years. Meanwhile, at least one person died in an accident related to the defective switch during that time period. Our investigation of this matter began in February of 2014, shortly after GM disclosed that certain of its older cars had a defective ignition switch that caused the front airbags to fail to deploy during crashes. The company acknowledged that the defect was connected with 13 deaths and many serious injuries. It has since acknowledged 2 more associated deaths. Now, as you can imagine, this has been a deeply difficult case, most especially for the families of the victims who died in GM cars. Deeply difficult. For us, it has been a challenging case for the agencies, for the prosecutors, and for me. As part of our investigation, we reviewed hundreds of thousands of documents. We interviewed scores of witnesses. But that's not why this case has been so challenging. It's been challenging and difficult because we've had to think long and hard about the appropriate resolution in this case. Paramount in our minds through every stage of the investigation has been the victims of the defective ignition switch. I met personally with families who lost loved ones in tragic accidents involving the switch. I will tell you that those were among the most searing moments I have ever spent in my 6+ years as a United States Attorney. And so with those victims in mind, and with a deep commitment to holding accountable those who caused such a profound tragedy, we have aggressively applied existing statutes in bringing criminal charges against GM. Now, one thing people should understand about the law. There is actually no existing law specifically designed to impose criminal penalties for this kind of conduct, the non-disclosure of safety defects by a car company. There have been attempts at such a law, but those attempts have failed. Even what's known as the TREAD Act, the law commonly understood to govern motor vehicle safety in this country, does not carry a criminal penalty in this situation where a car company fails to disclose a safety defect domestically. So given the lack of a particularized criminal statute, we have looked at broader statutes of general application, namely false statements and wire fraud. In the end, we can only do what the law allows and permits and what, in our best judgment, justice requires. Here, in our best judgment, justice requires the filing of criminal charges. It requires detailed public admissions. It requires a significant financial penalty, well above what GM has paid and will pay under its victim compensation program. Above all, justice requires measures to make sure this doesn't happen again, which is why we have insisted upon those admissions and the appointment of a federal monitor. This is not only about justice for certain families, but justice for the car-driving public going forward also. In this case, we have agreed to defer prosecution of those charges, notwithstanding the bad conduct here, for several reasons. First, as I've mentioned, the deferred prosecution agreement we've entered into with GM details factual admissions and the company's prompt agreement to appoint a monitor, which, by the way, you don't even get after a conviction at trial. Second, from the moment that top management came forward to disclose the defect in February of 2014, the company's cooperation and remediation have been fairly extraordinary. It conducted a swift and robust internal investigation. That doesn't always happen, I can tell you. It gave the prosecutors in my office real-time updates about the findings of that internal investigation, often revealing to the office what witnesses had said even before GM management was filled in itself. That doesn't always happen. GM got rid of a slew of employees, I believe 15, who were involved in the recall process that failed so miserably in this case. That almost never happens. And the company established a full and independent victim compensation program that has to date agreed to pay more than $566 million, again, far in excess of what a court might have ordered, and at far less cost to the victims, and that has never happened. So that cooperation is the reason why we are here after only 18 months in a complicated case, rather than 4 years or more. To be clear, good behavior after the fact does not absolve GM or any company of responsibility. But companies should be encouraged to act as GM did here to help the truth come out faster, to help victims' families get compensated earlier, to weed out the bad actors faster, to do everything they can to make sure tragedies like those that unfolded in this case never happen again. Now, with respect to this case, the investigation continues. I am not necessarily saying that charges will be brought or won't be brought against any particular individual. We have made determinations as to some, but not as to all. What I can say is that there are challenges, legal and factual, in cases like this. We have to examine the role of any particular individual within the company, the person's duties and specific responsibilities, the timing of his or her action or inaction. There are some people, as you might imagine, who had knowledge but did not make any disclosure, either to a regulator or to the public. And there are other people, as you might imagine, who made disclosures but didn't have any knowledge or didn't have complete knowledge. In those circumstances, any lawyer will tell you criminal intent can be hard to prove. So it is not always possible to bring a particular kind of case, but I can say that if there is a case to bring, we will bring it, and I think I can fairly say that no office anywhere in the country has prosecuted more individuals for white-collar offenses than this one. As for today's resolution, our unprecedented criminal cases in this area, in the auto industry, have had a significant impact. I think that's undeniable, as noted by some of the newspapers represented here today. Ask anyone at the Department of Transportation or in the transportation industry, and they will tell you that these cases have been something of a watershed. Because of these cases, there have been more recalls, there has been more attention to safety, more attention to transparency with regulators, and more focus on how to keep the driving public safe. This resolution and this case furthers that effort. Now, we didn't get here all by ourselves. I want to thank our many partners in this case for their hard work over the last 18 months. I want to thank the FBI, represented here today by Diego Rodriguez, the Assistant Director in charge of the New York Field Office, the Department of Transportation's Office of the Inspector General, represented by its Principal Assistant Inspector General for Investigations, Michelle McVicker, Special Inspector General for the TARP, represented by Inspector General Christy Romero, and NHTSA, represented by its Deputy Administrator, Blair Anderson. Finally, I want to thank the prosecutors in my office who have been responsible for this case, principally responsible for this case, Deputy Chief of the Criminal Division, Bonnie Jonas, and Assistant U.S. Attorneys Sarah Eddy McCallum and Edward Imperator. Now I'd like to call to the podium Diego Rodriguez of the FBI.
Thank you, Preet. Good afternoon. The FBI is proud to stand beside our partners to announce criminal charges against General Motors. No longer can this company's responsibility remain covered behind pure civil liability. As noted in the deferred prosecution agreement, GM admits to not only failing to disclose a safety defect to the National Highway Traffic Safety Administration, but also to misleading U.S. consumers about the same defect. Although we cannot put a mandatory value on the lives lost, we believe the previously noted agreement, which includes a $900 million financial penalty, is a fair and just consequence for corporate criminality. This penalty is meant to deter decisions that look to benefit the corporation at the expense of personal harm. We will no longer accept a business culture where expediency and the bottom line are put before the safety of people. General Motors can no longer hide behind the corporate veil. They are now accountable for their actions. Many thanks, as always, to our partners in this and so many investigations: U.S. Attorney Preet Bharara, National Highway Traffic Safety Administration Deputy Administrator Blair Anderson, Department of Transportation Office of Inspector General Principal Inspector General Michelle McVicker, and SIGTARP Special Inspector General Christy Romero. I would also like to thank and congratulate our corporate fraud investigative team that worked together on this case from all the agencies herein. Thanks.
Now I'd like to call to the podium the Department of Transportation's Michelle McVicker.
Thank you, everybody. On behalf of the Inspector General, Cal Scoville, I want to thank you and all other members of the multi-agency team for all the time and effort dedicated to working this case. The $900 million agreement is a clear signal to all of whose duty is to protect our public. Your most solemn obligation is to public safety. While we are pleased with the result, we have not forgotten that families suffered as a result of the failure of these ignition switches. They are not mere statistics. To the families and friends of those who have died, to those who were injured as a result of these incidents, the Inspector General and I offer our deepest sympathies for your loss and our highest admiration for your strength as you demonstrate that every day. Safety is a vital component of our mission and the Office of Inspector General's highest priority. We are committed to pursuing those who violate the Department of Transportation's laws and regulations, but safety begins with the auto manufacturers. When they become aware of safety issues, they must make timely disclosures and take swift and appropriate corrective action. These companies must live up to their responsibilities and obligations to the public who rely on their products for safe transport. It is my sincere hope that the steps we've taken and the agreement we've reached with General Motors will serve as a clarion call to all auto manufacturers of the need of unwavering vigilance when it comes to public safety. Again, I thank all of you and all of the families and all of the team members for their assistance on this case.
Thank you. Now let me call to the podium SIGTARP Inspector General Christy Romero.
I I'm Christy Goldsmith Romero, the Special Inspector General at SIGTARP, which is a law enforcement agency that investigates crime related to the bailout. The SIGTARP special agents took a leading role in this extensive investigation, working in very close coordination with U.S. Attorney Bharara's office and our other partners. More than 70 witnesses were interviewed. More than 1 million pages of documents and emails were analyzed. And to the family and friends of loved ones who lost their life, I'm here to tell you that we always kept your loved ones in mind while conducting the investigation. We know that nothing can take away your loss. We're sorry for your loss. So all we could do at SIGTARP is do what we do best, which is to be relentless in pursuing the truth so that you could know the truth, and be relentless in enforcing the law. The criminal conduct by GM that was found by SIGTARP and our partners here today defies comprehension. And perhaps the worst part of this tragedy is it was entirely avoidable. GM could have substantially reduced the risk related to this this deadly defect, by improving the design of a key that would cost less than $1. And they decided not to do so because of cost. Now, Americans stepped up and they bailed out General Motors. And now General Motors needs to step up and make substantial corporate changes so nothing like this ever happens again. I want to commend the Attorney General, Loretta Lynch. I want to commend the U.S. Attorney, Preet Bharara, for standing united with SIGTARP to ensure that there is accountability for the crimes committed by GM while they are in TARP. I really want to recognize the terrific prosecutors, Bonnie Jonas, Sarah McCallum, and Edward Imperator, as well as the Department of Transportation Inspector General and the Federal Bureau of Investigations for relentlessly pursuing the truth and enforcing the law with us. Thank you.
Thank you. And finally, let me call to the podium NHTSA Deputy Administrator Blair Anderson.
Hello, my name is Blair Anderson. I am the Deputy Administrator of the National Highway Traffic Safety Administration. Administrator Rosekind wishes he could be here today, but he is traveling with the Secretary Fox in Europe at a G7 ministers event for transportation. On May 16, 2014, the day NHTSA announced the resolution of its enforcement action against GM, the agency sent a criminal referral to the Department of Justice regarding GM's action. On behalf of the Secretary, the Administrator, and all the staff at NHTSA, I'd like to thank Mr. Bharara, his staff, and all their colleagues at the Department of Justice for their efforts to seek justice in this matter. At NHTSA, we are focused on safety rather than criminal matters, and today's announcement strengthens our ability to protect the traveling public in two important ways. First, the significant penalty imposed in this case is a meaningful deterrent against the kind of deception that GM employed in the ignition switch case. Today's announcement makes clear to all manufacturers that if they choose to conceal a safety defect, it's a very expensive choice. Given that NHTSA's civil penalty authority is capped at $35 million, a cap that the Department of Transportation has repeatedly asked Congress to raise, the use of criminal penalties is an important deterrent. Second, the size of the penalty is not the only powerful message of today's announcement. The decision of the Department of Justice to charge GM with engaging in a scheme to conceal a deadly defect from its U.S. regulator, us, NHTSA, is a strong reinforcement to NHTSA's safety efforts. The Motor Vehicle Safety Act's criminal provisions are limited, which makes DOJ's ability to invoke its criminal authority all the more powerful. This should leave no doubt with all manufacturers. If you choose to intentionally conceal a safety defect, it's a criminal offense. No enforcement actions or penalties, civil or criminal, can mend the families that were torn apart as a result of GM's ignition switch incident. What we can do and what we must do is use every tool we have at NHTSA to improve safety going forward. NHTSA is actively using the lessons of this episode to improve our internal processes and systems of identifying and addressing safety defects. Today's announcement is an important reinforcement to those efforts, and we are grateful to the U.S. Attorney's Office and the Department of Justice for all their assistance in this matter.
Thanks, Blair. Happy to take your questions.
Just to be clear,
Yep.
I know you say it's not set in stone that individuals won't be charged here, but it certainly appears that way. A lot of families that we've spoken to are bitterly disappointed by this. Are you saying you didn't have the evidence, or you don't have the authority?
I understand people's disappointment when bad things happen and when tragedies unfold. People want accountability. No one understands that outside of the victims' families more than the people in this office. And as I mentioned, I had personal meetings with the families. People in my office had even more with some of the families. At the end of the day, I'll just repeat what I said in my remarks. The law is the law, and the facts are the facts. We're not done, and it remains possible that we will charge, an individual. But the law doesn't always let us do what we wish, we could do to satisfy a natural inclination on the part of people who are harmed by some bad conduct for accountability. We're the most aggressive office, I think, around. We don't get accused often of being under-aggressive. So if there's a way to bring a case like that, we will bring it. But there are challenges, as I described, in bringing a case against a particular individual. The responsibility for being forthright and for making disclosures about safety defects fell to the company. The regulations and the laws make that a responsibility of the company. Obviously, there are people in the company who have to carry that out. But it turns out to be the case sometimes, and I'm speaking generally about cases, that a particular person may have had only partial knowledge and contributed in a chain of actions and disclosures and non-disclosures that led to something bad happening. And again, we apply the laws as we find them, not the laws as we wish they might be. I mentioned in my remarks that there had been attempts over time. I think at the initial passage of the TREAD Act, there was an effort made to make to have a criminal sanction with respect to cases that might match a case like this. I think at some point, and people forget also, I think, that it's not the case that it's actually a criminal violation to put into the stream of commerce a defective automobile that might kill people. The crimes that we can charge are based on laws that actually exist. There was once upon a time, give me the other side, there's once upon a time, I think someone made an effort to make it criminal for someone knowingly to put into the chain of commerce a defective automobile. In other industries, there are violations that arise from facts like that. That's not the case here.
Does that not shock you? That's not illegal?
So I've been the U.S. Attorney for 6 years. There's a lot that doesn't shock me because I've been doing this for a long time. There are gaps in the law in a lot of different places. It's interesting. There's a lot of discussion about overcriminalization in some contexts. I don't see a lot of overcriminalization in this context. Yeah.
Can I ask, why did you decide the GM would not have to plead guilty? And in the case of Toyota, where there's about 5 or 6 confirmed deaths, there was a $1.2 billion penalty, and you got many more times that.
Yeah, look, every case is different. They're both automotive companies, and they both had problems and issues and failures with respect to disclosures about safety. That said, you look at each case on its own, just like you look at every individual defendant that you might prosecute based on the facts and circumstances alone. I think I spent some time in my remarks referring to the extraordinary cooperation. That's not dispositive, but in combination with other things, including the level of culpability by the company, including the amount of reform that has taken place, including the termination of 15 people who had done bad things in their view, including the coming forward with lots of information, including the voluntary setup of a fund administered by the very respected Ken Feinberg to make sure that families aren't going to be sitting in litigation in court at great expense for years and years and years, like some industries and some companies within those industries do. In light of all of those things together, in our judgment, we thought that in this case, a deferred prosecution was okay. You get a lot with a deferred prosecution agreement, more sometimes than you might get if you had a criminal litigation that would last a long time, with lots of lawyers arrayed on both sides of the V. including, as I said, a monitor, including a robust admission of facts, and including lots of other reforms. If you go to trial, I'm not saying that it's not appropriate to go to trial. We, by the way, have been one of the pioneers in recent years of charging companies, whether it's SAC Capital or the largest bank in France. When we think it's appropriate, we'll charge a company. We have no fear of doing that. We have no qualms about doing that when we think it's appropriate. We also don't have qualms about stepping back from that if we think overall, in our best judgment, and maybe our judgment is not perfect, but in our best judgment, given all the factors, that we thought was the most appropriate result in this case.
You talked
Yeah.
about the
General Motors has opposed criminal penalties in every piece of legislation since 1966. They've lobbied against it overtly, hired special attorneys to stop it. Would that be something you would consider in your oversight going forward? Because there is pending now an auto safety transportation bill in which has been proposed that there should be criminal penalties. If General Motors continues to oppose that, would you consider that in your oversight of the company going forward? And do you favor putting criminal penalties specifically into the auto safety law?
I used to work in the Senate once upon a time, and I had a professional view about what laws should or should not be amended. Now I just enforce the laws as they exist, so I have no professional view. I have personal views that I won't share with you. I do think that there are lots of other folks who are in a better position, who are not merely prosecutors, to decide what should happen with a particular law and how a company should be treated if it decides to oppose a particular kind of law. And I think I would leave that, because we have our hands full, to the Senate and to the House.
You've
Yeah.
talked about behavior. You've talked about the pre-behavior and post-behavior from this company. Can you characterize the criminal behavior of General Motors?
Yeah, I mean, I think I've done that. I think, you haven't had the time yet, but I think you should read the fairly robust statement of facts. The company itself, in combination with all the people who had some responsibility for making sure this didn't get to the point where it got, that the public didn't know between 2012 and 2014 that there was a safety problem. Our view is, as an institutional matter, they let the public down. And I think it's as simple as that. There are a lot more details in the statement of facts that you can read, but to sum it up, they didn't tell the truth in the best way that they should have to their regulator and to the public about a serious safety issue that risked life and limb for Americans.
You mentioned that
there was a specific engineer in this case who changed the part of that part number, who subsequently given sworn evidence about that he had no idea how the part came to be changed. I think many people think it's somewhat extraordinary that there isn't a criminal case already against that specific individual whose role appears to be absolutely pivotal in this.
Yeah, as I said, we have made determinations as to some, but not as to all. And I'm not going to go into chapter and verse with respect to each individual. And I appreciate what you're saying. I think it's often the case too when prosecutors and investigators and agents dive down deep and analyze and look at every single document, every single bit of testimony, that there's sometimes more than meets the eye with respect to being able to prove specific criminal intent on the part of an individual. As I said before, it is not a crime, as far as I'm aware, for a company to have a product on the market without more, a product on the market that might kill people. The criminal exposure that arose in this case and that federal statutes allow us to prosecute someone on, or a company on, arise from disclosure or lack of disclosure. So the fact that something went wrong as a safety matter, again, that's not in any of the acts that we're talking about. It is with some industries and not with this one. So you have to be able to prove, with respect to any particular person, that that person knew the facts, knew the safety problems in a very specific way, had an obligation to tell someone else, a regulator of the public, about them, and then made misstatements to the public. And it turns out to be the case sometimes when you look at a company where responsibility is diffuse. I'm not saying this is a good thing. This is actually a problem in business culture. There's a person who recently wrote a book about this called, referring to the siloing problem, in terms of how that's bad for creativity and for business. It's also bad from a compliance perspective. But it turns out that if you have a complex structure, sometimes, in which various people knew little bits of things and other people had responsibilities for making statements to the public, it's not as easy as it looks sometimes.
You mentioned that there were that the company has admitted to 15 deaths. Now, the Center for Auto Safety puts together upwards of 300. Does the U.S. Attorney's Office take a view of the total number of deaths?
You know, there is a lot of debate and back and forth with respect to how many people died and what the specific causation was, because in some circumstances that's hard to prove as a definitive matter. What I can say is the company has taken responsibility for 15. They have set up a compensation program led by, as said, by the very respected Ken Feinberg, who I think puts the number who should be compensated without having the whole back and forth scorched earth litigation in court at 124. The most important thing from our perspective is that we are dealing with the company appropriately, and that through whatever process, people who are deserving of compensation, even though they can never be fully compensated, will get compensated.
You said GM had a lot of problems, obviously, in safety culture. Did your investigation look at GM's handling of other recalls or other safety issues? Are you satisfied that the ignition switch was the only defective?
I'm not going to go beyond what we had, but we tend to look broadly at things, but I'm not going to go beyond what is in our statement of facts.
There's a monitor that's supposed to be appointed. Who is that person?
The person has not been determined yet. We lay out in the deferred prosecution agreement, which I think is being distributed, the procedure by which that's done. It's done in consultation with us, as we've done in many other cases, and that'll be done as soon as possible.
Thanks, everyone.